Hi, I'm Kimberly Davis, co-founding member of the law firm of Speratos Davis, and I'm here to talk with you about closing arguments. Closing arguments are essentially the show. It's your opportunity as a lawyer to stand in front of that jury and for the first time explain to that jury how the theory matches the evidence and provide that with argument. Now, in opening statements, you have hopefully established a rapport with the jury, maintained credibility or began credibility. You will maintain that throughout the lawsuit, and then you will discuss how you've kept your promises throughout the case and how the evidence and the law combine to require the jury to find in your favor. Credibility begins at the opening statement, ends with closing argument. The jury will not believe you and rule in favor of your client if they don't think you're credible. You made promises to that jury during opening statement that the evidence will show X, Y, and Z. And as you talk with the jury in closing arguments, you want to show the jury how indeed the evidence has shown what you promised them it will show. When discussing evidence with the jury, you'll want to talk about specific pieces of evidence that correlate with the applicable law. Burdens of proof will be read to the jury by the judge, typically at the conclusion of closing arguments. So when you're talking with the jury, you'll want to match or marry the evidence with the law that they are about to hear. Sometimes courts allow you to ask the jury to promise you during opening statements that the jury will follow the law, even if the jury does not care for or believe in the particular law. And that's important because in closing argument, you may be allowed to remind the jury of that initial promise, how you've kept your promises in delivering the evidence in accordance with the applicable law or burdens of proof, and how the jury now should keep its promise in applying the law to the evidence and ruling in your client's favor. Carrying your theme throughout the case and into closing argument is essential. As I've mentioned, you are taking pieces of evidence and describing for the jury how that evidence, when applied to the law, should result in a verdict in favor of your client. In this day and age, we have a lot of visual learners on the jury. Show the jury that evidence. Let them see it. Could be a picture of a scene, picture of some instrumentality. If the case involves a ladder, bring the ladder in. If it involves a gun, bring the gun in. A tool. Let the jury get a better feel for the evidence by seeing it during your closing argument. Not every case is perfect. I dare say there's no case that is perfect. During closing arguments, as a credibility piece, you may want to make some concessions about your weaknesses in the case. Concessions about your responsibilities. That is a way to build credibility. The complexity of the case and your comfort level with technology will govern how many bells and whistles you include in the actual closing argument. You may just want to stand in front of the jury and talk with them. You may want to show them some exhibits. Some attorneys use a flip chart with key phrases, key wording that underlie and support your theme in the case. Juries respond to that. Juries tend to not care for very long closing arguments. Sometimes the judge will limit the amount of time that you are going to have in front of the jury. So it's important to send your message, support the message with evidence, support the message with visuals, and thank the jury for their time. Not unlike the comfort level issue with technology, it would be best, as you stand before the jury, if you're just yourself. Look that jury in the eye. Identify which jurors you need to concentrate on more than others. And be yourself. Carry the theme through. apply the evidence to the law, and explain to the jury why they should rule in favor of your client. Closing arguments can be a passionate and an emotional presentation for the jury. It's important to keep your eye on the prize. Remember your theme. Avoid making any disparaging remarks or insulting remarks. Make sure that what you say during a closing argument is supported by the evidence. Try to avoid reading from a script in your closing arguments. My suggestion is to do what is comfortable for you. I tend to have an outline of notes in a large Sharpie marker outline that I can casually look toward while I talk with the jury. Closing argument is indeed the time for you to provide a complete picture to the jury with argument. Provide the jury with the ammunition, the evidence, your argument, the law, to rule in your client's favor. It is the most exciting time. It is wonderful to stand in front of the jury and to look into their eyes and to have them concentrated on you and listening to you about why they should rule in your favor. Take that opportunity, embrace the opportunity, have fun. This is indeed the show, and I hope you enjoy it.